Welcome to the deep dive. Today, we're doing something a bit different, really zeroing in on your specific journey. We're looking at the recent real estate practice test you took and that 83% score seriously. That's a fantastic result. It really shows you've got a strong handle on the basics.
Absolutely. 83% is nothing to sneeze at. You're clearly putting in the work.
Exactly. But, we're here today to tackle those few questions, those concepts that maybe felt a little slippery, the ones you couldn't quite nail down. We want to turn that almost got it into absolutely understand it.
Right.
So our mission for this deep dive is to explore those precise areas that might have tripped you up on the way to that 83%. We want to make sure these concepts don't just click for the exam, but really stick with you for your whole real estate career.
What's interesting is that the questions people miss, they often highlight these really subtle, nuanced areas. Things that are, frankly, crucial for actual day-to-day practice, not just for passing a test.
Good point.
So we'll unpack those distinctions, help connect the dots between related ideas, and really solidify your understanding. The goal is for you to feel completely confident moving forward.
That's exactly it. We want to demystify the tricky stuff.
Yeah.
So in this deep dive, we're going to clarify some key concepts across, I think, three main areas that often challenge new agents. First up, we'll untangle the complexities of agency relationships. I mean, that's really the foundation of your ethical and legal duties, right?
It absolutely is. The backbone of the profession.
Then we'll shift gears and look at understanding different property types and the nuances of how ownership works, making sure you're crystal clear on what's actually being bought and sold.
Critical distinctions there.
And finally, we'll get into some essential transactional specifics, the nuts and bolts that make sure a closing is smooth and legally sound. So get ready to turn those lingering question marks into solid understanding.
Sounds good. Let's dive in.
Okay, our starting point today is agency. As you said, it's foundational. It dictates how you, as a real estate professional, interact with clients, with customers. But boy, it can be layered with intricacies. These relationships and duties, sometimes it feels like navigating a legal maze.
It really can. Agency relationships, they're fundamentally built on trust, but they're also governed by very specific legal frameworks. Some are explicit, written down, others are sort of implicit, understood.
Right.
And having a really thorough grasp of how these relationships are created, what their boundaries are, and importantly, the different ways they can end. That's paramount. It's not just about the test, as we said. It's fundamental for avoiding liabilities, avoiding ethical mistakes throughout your entire career.
Absolutely essential. And one of the areas that seems to consistently cause a bit of confusion is how agency can be created subtly, or even just appear to exist. Let's dig into a question that explored ostensible agency and agency by estoppel. The question was something like, which statement is true about ostensible agency and agency by estoppel? This one likely tripped up a few people on their way to that 83% because the terms sound similar and they are very closely linked.
They are indeed. And understanding the sequence, sort of the cause and effect here, is really key. Let's break down ostensible agency first. Basically, imagine someone acting like they're an agent, even without a formal agreement. Ostensible agency is created when the principal, that's the person the agent would be working for, fails to actively stop that impression.
Fails to stop it, so they see it happening and just let it.
Exactly. It's about the outward appearance, the principal's inaction, their silence, when maybe they should have stepped in and corrected things. If you, as the principal, let someone give a third party the impression they're your agent, and that third party reasonably believes it, well, that's ostensible agency. The principal isn't necessarily saying, yes, they're my agent, but crucially, they're not saying, hold on, that person doesn't represent me.
Okay, so it's about the look of things from the outside, and the principal just kind of passively accepting that look. Like, if you're in a shop, someone helps you, you assume they work there. If the owner sees it and says nothing, that's creating that ostensible link.
That's a good analogy, yes.
Yeah.
Now, agency by estoppel, that's the next piece. It's the legal consequence that can flow from that ostensible agency situation.
The consequence?
Right. It's when the principal and the supposed agent are legally barred or estopped, that's the legal term, from denying that the agency existed after that ostensible situation is played out.
Yeah.
The law basically steps in to prevent unfairness to the third party who reasonably relied on that appearance, maybe to their own detriment.
So they can't just say, oh, wait, they weren't really my agent after the fact if they let it look that way.
Precisely. If you stood by, let someone appear to be your agent, and a third party acted on that belief and got hurt somehow,
Yeah.
the law says, nope, you're stopped from denying it now to escape responsibility. You had the chance to correct it, and you didn't.
Okay, I think I'm seeing the connection. Ostensible agency is the appearance created by the principal's inaction,
Right.
and agency by estoppel is the legal hammer that says, you let it look that way, now you have to live with the consequences if someone relied on it. One kind of sets the stage for the other.
You've got it. That's the flow. Ostensible agency creates the environment. Estoppel is the potential legal outcome within that environment. Think about a real estate scenario. This might make it clearer for you. Imagine a broker, the principal. They regularly let an unlicensed assistant, let's say, hand out business cards that are a bit vague, maybe imply they can talk about property values. Maybe the assistant even hosts open houses and answers quite specific questions from buyers.
Okay.
The broker knows this is happening, maybe even encourages it slightly, but certainly doesn't step in to clarify the assistant's limited role to potential buyers. That's ostensible agency. Now, if a buyer, the third party, relies on that assistant's advice, maybe about value, maybe about repairs, and ends up overpaying or buying a problem property.
Then the broker might be in trouble.
Yes, the broker might then be estopped in court from denying the assistant was acting as their agent in that instance. The court could hold the broker responsible for the buyer's damages, even without any formal agency agreement covering that specific advice.
Wow. Okay, so the big takeaway here for you as you're preparing for your license and career is that your silence, your inaction, it can have real legal weight.
Absolutely.
It's not just about the formal agreements you sign. It's about actively managing how things look, correcting misunderstandings right away, because not doing so could lead to significant legal problems, even without that explicit agency contract. It's a powerful reminder of how seriously the law takes these appearances.
It truly is. Vigilance is key.
All right, so from how agency can be created, let's pivot to one of the most crucial duties within an agency relationship: confidentiality. This next question you encountered likely touched on a common ethical tightrope. Jim needs to sell his home quickly to start a new job out of state. This makes him very anxious. Is it okay for his listing agent to tell potential buyers about Jim's anxiety without his permission? This really cuts to the core of what you can and cannot share as an agent.
Confidentiality. Yes, it's arguably one of the most paramount fiduciary duties. It fundamentally requires an agent to keep private information, shared by the client, completely private, unless, of course, the client gives explicit consent to share it, or in some rare cases, if the law absolutely mandates disclosure.
And the really critical part here, the part that sometimes surprises people, is how long this duty lasts, right?
Exactly. What's crucial to remember, and maybe this was the point that needed clarification for you, is that this duty of confidentiality lasts forever. It extends far beyond the closing date, beyond the termination of the agency relationship itself.
Forever. So years later, you still can't gossip about why Jim was so desperate to sell.
Nope. Legally and ethically, you cannot. It's about protecting your client's interests indefinitely. And this brings up a really important distinction that often causes confusion: the difference between a material fact and confidential information.
Ah, yes. Material facts must be disclosed, right?
Correct. A material fact is something significant about the property itself. If a buyer knew about it, it could reasonably make them change their mind about buying, or at least change the price they're willing to pay. Think a leaky roof, foundation issues, or, as you might recall from other study materials, if the property is located in a designated floodplain. Those things must be disclosed to all parties.
Okay, property defects, environmental hazards, those are material.
Right. But a seller's motivation, like Jim's anxiety about his job and needing a quick sale, or maybe their financial difficulties or personal reasons for moving, that is almost always considered confidential information.
And you can't disclose that without permission.
Absolutely not.
No.
Primarily because revealing it could directly harm your client's negotiating power. If buyers know Jim is desperate, what are they going to do?
Offer less money.
Exactly. They'll likely make lower, more opportunistic offers, directly hurting Jim's bottom line. Disclosing his anxiety goes directly against his best interest, which you, as his agent, are sworn to protect.
So the real insight here, and this is crucial for practice, not just the exam, is that upholding confidentiality isn't just about being polite or professional.
Not at all.
It's a serious legal and ethical obligation. Violating it can have severe consequences. We're talking disciplinary action from the licensing board, potential lawsuits from the client claiming damages, even losing your commission on the deal. Imagine risking your license because you let slip that your seller was anxious.
It's a huge risk.
Yeah.
Your silence, in this context, is actually one of your most valuable tools in protecting your client, specifically their financial leverage in negotiations.
That makes perfect sense.
And just to build on that, Maintaining strict confidentiality is fundamental to building and preserving trust. And trust, as you know, is the absolute bedrock of any successful client relationship in real estate. Clients need to feel totally secure that when they share sensitive personal or financial details with you, that information is safe, handled discreetly, and used only to benefit them within the bounds of the law.
Okay, let's shift focus slightly within agency to a concept that can get tangled, especially when multiple brokers are involved, subagency. This next question you tackle probably involved a scenario like this. Salesperson Ebony works for broker Bert, representing seller Jerry. Then, cooperating broker Molly from a different company brings a buyer, but this buyer is just a customer, not Molly's client. The question might have been something like, which statement is true about this situation? This really tests understanding of who represents whom, especially regarding subagency.
Yes, this is definitely a key area where clarity is needed. And the foundational principle, the starting point, is always this. Agency relationships are created at the broker level. All the associate licensees working under that broker, the salespersons like Ebony or even broker associates, they all represent their principal broker.
So Ebony works for Bert, and Bert holds the agency relationship with the client, Jerry. Ebony acts on Bert's behalf.
Exactly. Now let's define subagency. Simply put, a subagent is an agent of an agent.
An agent of an agent.
Okay. So in this scenario, Ebony, as a salesperson working under broker Bert for the client Jerry, is technically considered a subagent of Jerry. She operates through Bert, who is Jerry's primary agent.
Okay, so Ebony is Bert's agent, and through Bert, she's a subagent to Jerry. Makes sense. But what about Molly? She's from a different brokerage, and she's bringing a buyer who is just a customer. How does she fit in? Is she a subagent too?
This is the critical part. If Molly is not representing the buyer with a formal buyer's agency agreement, meaning the buyer is just a customer to her, and she is instead working to help the listing broker, Bert, find a buyer for Jerry's property, then yes, Molly is operating as a subagent of the listing broker, Bert.
So she's Bert's subagent.
And therefore, by extension, she's also a subagent to the seller client, Jerry. The key insight, and this might have been the core of the question you missed, is that in this specific setup, both Ebony, working for Jerry's broker, and Molly, the cooperating broker bringing a customer, are operating as subagents to seller Jerry. Both legally owe their primary fiduciary duties to Jerry, the seller.
Wow. So even though Molly is the one showing the property to the buyer, her legal loyalty is actually to the seller, Jerry.
If she's acting as a subagent, yes, that's the definition.
That has huge implications for the buyer, doesn't it? If Molly is a subagent, that buyer she brought is essentially unrepresented by anyone with a fiduciary duty towards them.
Precisely. The buyer is a customer, owed honesty and fair dealing, but not loyalty, not confidentiality about their own position, not obedience. Molly, despite interacting directly with the buyer, legally works for the seller's best interests.
This is such a crucial distinction, especially, you mentioned California. I understand subagency is legal there, but maybe not that common anymore.
That's right. It's legal, but relatively rare in practice today, largely because of the liability risks it creates, particularly for the listing broker who's responsible for the actions of these subagents they may barely know. But understanding the concept is vital for the exam and for recognizing the situation if it ever arises.
It really underscores the absolute importance of clear, upfront agency disclosure and getting informed consent. Everyone needs to know who is working for whom.
Absolutely. Without that clarity, a buyer could easily and mistakenly believe the agent showing them homes is their agent, working solely for them, when legally, that agent's loyalty lies entirely with the seller. That's a recipe for conflict and misunderstanding if it's not explicitly laid out and agreed upon by everyone involved.
And building right on that, let's revisit a fundamental point we touched on, which clearly caused some confusion on the test for you, judging by the 83%, the core difference in duties owed to clients versus customers. The question described an agent Patrick, who showed reasonable care and skill, honesty, and good faith when dealing with both seller Beth and buyer Mike. Then it asked, what does this tell you about his relationship with them? This tricks people up because Patrick sounds like a good agent to everyone, so maybe he's everyone's client.
Right. It sounds like he's doing the right thing by everybody, which he is, but it doesn't automatically make them both clients. We really need to hammer home that core distinction again. An agent works for a client. They owe that client the full range of fiduciary duties. In contrast, an agent works with a customer. They owe the customer fairness, honesty, basic competency, but not those fiduciary duties.
Okay, so what are those baseline duties, the ones Patrick showed, that are owed to everyone, client or customer?
There are universal duties, things like disclosing agency relationships up front,
Hmm?
disclosing known material facts about the property, acting with honesty and fair dealing, exercising reasonable skill and care in their work, and properly accounting for any funds they handle. These are owed to both clients and customers. It's the basic standard of professional conduct.
The minimum standard.
Exactly. But the deeper, more extensive fiduciary duties, the ones we often summarize with that acronym OLDISIR, obedience to lawful instructions, loyalty undivided, disclosure of all relevant information, not just material facts, confidentiality, as we discussed, accounting in a broader sense, and reasonable skill and care. These comprehensive duties are owed only to clients.
So back to Patrick. His actions, reasonable care, honesty, good faith, they just demonstrate that baseline professional conduct required for everyone. It doesn't tell us who his client actually is.
Precisely. His actions alone don't reveal the specific nature of his relationship with Beth or Mike. He could have Beth as a client and Mike as a customer. He could potentially have Mike as a client and Beth as a customer, though less common if Beth is the seller. He might even theoretically be acting as a facilitator with no agency relationship with either, just owing them the basic duties, though that varies by state and situation. The point is, the described actions fit the universal duties, not necessarily the fiduciary ones.
So why does this cause so much confusion? Is it just because everyone expects decent treatment?
I think that's a big part of it. Everyone involved, rightly, expects ethical, honest treatment. But the legal depth of the commitment, the full weight of those fiduciary obligations, that's reserved exclusively for clients. Understanding this sharp distinction is vital. It protects you, the agent, from potential liability by clearly defining your obligations to each party. And, just as importantly, it ensures that your clients receive the full, dedicated representation they're legally entitled to. It really comes down to clear disclosure and managing expectations from the very start.
That clarity and upfront disclosure is absolutely critical, especially when things get potentially complicated, like in a dual agency situation. This leads us to a question about a broker, Kenja. She started with a single agency relationship with Heller Franklin, but then, 2 weeks later, a buyer pops up who is also represented by Kenja's brokerage. The question was, what should Kenja do now? This is a classic scenario where single agency can quickly become dual agency, creating a significant ethical crossroads.
It is a classic and very common scenario. Let's define dual agency clearly first. It occurs when one single broker or brokerage firm represents both the buyer and the seller in the same transaction. It most often happens in-house, meaning both clients are represented by the same firm, even if different individual agents within that firm are working with each party.
Right. And the fundamental problem, as we've kind of hinted at, is that dual agency inherently compromises those key fiduciary duties, especially full disclosure and undivided loyalty. You can't really be 100% loyal to two opposing sides simultaneously, can you?
Exactly. The buyer wants the lowest price and best terms. The seller wants the highest price and best terms. Their core interests often conflict directly. It's simply impossible for one agent or one brokerage to provide undivided loyalty and full disclosure to both sides at the same time without some inherent conflict or limitation arising.
Makes sense.
And because of this inherent compromise, this is why informed consent in writing is an absolute legal must from both parties before a broker can proceed as a dual agent. The broker, Kenja in this case, has the primary responsibility to clearly explain the implications, what duties won't be fully provided before either client agrees to it. This isn't just a suggestion, it's a strict legal and ethical requirement.
So when this situation arises for Kenja, she finds herself potentially representing both sides. What are her actual options? She can't just ignore it and carry on as if nothing changed, right?
Absolutely not. That would be undisclosed dual agency, which is illegal and unethical. Kenja essentially has two main paths forward, legally and ethically. Option 1, she fully discloses the situation and the limitations of dual agency to both Franklin, the seller, and the buyer, and obtains their explicit informed written consent to act as a dual agent.
Okay, get permission from both, knowing the limitations. What's option 2?
Option 2, if one or both parties are uncomfortable with dual agency or don't consent, Kenja must release one party from their agency agreement. She has to choose to represent only one side, either continue representing the seller, Franklin, and refer the buyer elsewhere, or terminate her agreement with Franklin and represent only the buyer, if Franklin agrees to the termination. She cannot proceed representing both without that explicit dual agency consent.
The implications here seem huge. If an agent messes this up, engages in undisclosed dual agency, what happens?
The consequences can be severe. Loss of license, forfeiture of the entire commission from the deal, lawsuits from either or both clients claiming their interests were damaged. It's serious business. And for the clients, even if they consent, they need to understand that they aren't getting that undivided loyalty and complete advocacy they might expect from a single agent. They are agreeing to a limited form of representation.
It just hammers home again how vital transparency and explicit written consent are in every facet of real estate.
It truly does. The law is structured to ensure that even if the representation model shifts or becomes limited, it must be fully understood and unequivocally agreed upon by everyone involved. It's all about protecting the consumer and maintaining the integrity of the transaction.
Okay, let's shift our focus now from the people involved, the agents, clients, customers, to the properties themselves. We need to explore some key distinctions in how real estate is defined and how it's owned. Getting this right is absolutely fundamental to your day-to-day work as an agent.
Absolutely. Real estate isn't monolithic. It comes in many forms. And the legal implications, the ownership rights, the responsibilities, they can change significantly depending on the type of property and how the title is held. These details, which might seem minor, are actually critical for advising clients properly and for buyers or sellers to fully grasp what they're getting into.
Definitely. And this next question you face perfectly highlights one of those crucial differences. It was about PDs versus condominiums. The scenario described Kenya buying a vacation property. She owned her unit individually. She co-owned common elements like a pool and gym. But the key detail was she also had her own private yard and building. The question asked, what kind of property is this most likely? This often gets mixed up because both involve common areas.
That shared feature, the common elements, is exactly where the confusion usually starts. Let's clearly define them. A condominium typically involves individual ownership of a specific unit, often described as airspace, usually within a larger building. Think of an apartment on the 5th floor.
Right, you own the space inside your walls.
Correct. And you also hold an undivided interest along with all other owners in the common areas, hallways, elevators, the roof, the pool area, etc. But crucially, in a standard condo setup, your individual ownership usually doesn't include a private yard or a separate detached building structure. Your ownership is generally confined to that interior airspace.
Okay, so condo slice of a bigger building, shared common stuff, usually no private land or separate structure attached to your specific ownership.
Generally speaking, yes. Now, a planned unit development, or PUD, is a bit different. It's a type of subdivision that includes residential dwellings, maybe some non-residential elements too, and almost always has shared recreational facilities co-owned by the individual lot owners, often as tenants in common. The key distinguishing factor for a PD, and this is vital for Kenya's scenario, is that PDs often depart from standard zoning rules. This departure allows for individual ownership of a separate, often detached dwelling, which can include its own private yard and the land directly beneath the house, while still sharing those common amenities like a community pool or clubhouse.
Ah, so that specific mention of a private yard and building in Kenya's situation, that's the smoking gun.
That's the critical clue, yes.
Yeah.
It strongly suggests it's not a traditional condominium and points directly towards it being a PUD. That possibility of owning your own separate structure and yard while still being part of a larger development with shared facilities is characteristic of many PUDs.
So Kenya gets a blend private ownership of her house and yard, plus that shared interest in the pool and gym.
Exactly. It offers a different bundle of rights compared to a typical condo where you generally don't own the land under your unit or have a private yard tied directly to your deed. Understanding this difference is crucial.
And the significance for you as an agent is huge, right? You need to match clients correctly. If someone says, I want a yard, showing them only traditional condos won't work, you need to understand PUDs.
Absolutely. It's about managing expectations and delivering what the client actually wants and needs. It also impacts things like HOA fees, maintenance responsibilities, who fixes the roof in a condo versus a PUD, and even potential restrictions on modifying your property.
So it really drills down to what specific bundle of rights is the buyer actually acquiring? A PU offers a different legal setup and lifestyle proposition than a standard condo. Knowing that difference protects your client and ensures they make an informed decision.
Precisely. Clarity on ownership structure is non-negotiable.
And speaking of ownership structures, let's tackle another area that's particularly relevant here in California, being a community property state, but the principles apply elsewhere too. This question was about community property and how it treats inherited assets. The scenario involved Lola and Anissa, a married couple. Lola inherits a condo in Miami from her uncle. The question was, is this Miami condo considered community property in California? This definitely gets into the weeds of mine versus ours in a marriage.
It certainly does, and the rules are quite specific. First, let's define community property in the California context. Generally, it means any property assets, income acquired during the marriage by the effort, skill, or industry of either spouse is considered owned equally, 50-50, by both spouses.
So salaries earned during the marriage, a house bought with those salaries. That's community property.
Typically, yes. Both spouses usually have an equal interest. Both need to sign off to sell it. And it would likely be divided equally if the marriage ends. That's the default for assets acquired through joint effort during the marriage.
Okay. So what's not community property then?
That brings us to separate property. This category includes property owned by either spouse before the marriage. And critically for Lola's situation, it also includes property acquired during the marriage by one spouse through gift, inheritance, or devise, meaning left to them in a will. This type of property remains the individual spouse's separate property.
Ah, so the inheritance from Lola's uncle, even though she received it while married, it falls under that separate property rule.
Exactly. The fact that she inherited it makes it her separate property under California law. Her marital status at the time doesn't change that classification.
Mm.
And interestingly, neither does the property's location. The fact that the condo is in Miami is irrelevant to how California classifies it based on how Lola acquired it through inheritance.
So inheritance trumps location and marital status for classification purposes here.
In this specific context, yes. The source of the acquisition is the key determinant for separate property via inheritance. Now, just for completeness, California also recognizes something called quasi-community property. Yeah, that's property acquired outside California that would have been community property if the couple had been living in California at the time. But that's not Lola's situation. Hers is clearly separate property via inheritance.
Got it. So the big takeaway here, especially for couples or anyone advising them, is how incredibly important this distinction between community and separate property is for real-world stuff. Estate planning, divorce settlements, even just managing assets day to day.
Absolutely. It directly impacts who has control over what, who needs to sign off on a sale, how assets might be divided in a divorce, and who inherits the property if one spouse passes away.
Mm-hmm.
These aren't just abstract legal concepts. They have profound financial and personal consequences.
Understanding these rules really helps clarify financial rights within a marriage and can prevent some really nasty disputes down the road.
It really can. It highlights that it's not just about what property you have, but critically, how and when you acquired it, especially within the context of marriage and specific state laws like California's community property system.
Okay, staying on the theme of different types of ownership, let's define what it really means to own property in a more permanent sense. This question was about Alfonso, who owns a freehold estate, it asked. Which of the following is true about Alfonso? This gets to the fundamental nature of property ownership versus, say, just renting.
Right. Let's start broad. An estate in real property just means you have a possessory interest, the right to occupy and use a piece of property. Within that, there are major categories. A freehold estate is a type of ownership characterized by its indeterminate length. That's the absolute key phrase.
Indeterminate length, meaning it doesn't have a set end date.
Exactly. It implies a significant degree of ownership, not just temporary possession. It usually includes what we call the full bundle of rights. The right to use the property, enjoy it, sell it, lease it, give it away, exclude others unless the estate is specifically limited in some way. Common examples of freehold estates are fee simple absolute, the most complete ownership, fee simple defeasible, ownership that can be lost if a condition is violated, and life estates, ownership for the duration of someone's life.
Okay, so freehold ownership potentially forever, full rights unless limited. How does that contrast with the other main type?
The main contrast is with a leasehold estate. This is considered a non-freehold interest. It's created by a lease agreement, and the right to occupy the property is for a fixed or determinable period, like a one-year lease on an apartment. With a leasehold, you have possession, the right to occupy, but you do not have ownership of the property itself. The landlord retains ownership.
Got it. So leasehold, temporary possession, fixed term, no ownership, freehold, ownership, indefinite term, potentially, bundle of rights. The indeterminate length is the defining characteristic of freehold.
Precisely. So for Alfonso in the question, owning a freehold estate means his right to the property isn't tied to a specific end date like a renter's. He has ownership rights, use, enjoyment, disposal for an unspecified duration. It signifies a much more permanent and complete form of holding property compared to a lease.
This distinction seems fundamental for anyone buying or investing. Are they getting true ownership, freehold, or just the right to use it for a while, leasehold?
It's absolutely fundamental. It impacts everything. Long-term investment strategy, your ability to make changes or improvements to the property, how you can finance it, its resale value, and marketability. Understanding whether an interest is freehold or leasehold is crucial for assessing the true nature and value of the property right being acquired.
All right, let's pivot now into our final section, focusing on some of the real nuts and bolts of transactions and legal specifics. These are the areas where getting the details exactly right is absolutely critical to ensure everything closes smoothly and legally. Precision is key here.
You're absolutely right. The details in areas like title insurance, calculations, and termination clauses, they might seem small, but errors or misunderstandings here can genuinely make or break a deal, or worse, lead to legal problems after closing. Mastering these specifics really protects everyone involved, buyer, seller, lender, and you, the agent.
Couldn't agree more. Let's start with one that directly protects the money side: lender's title insurance. The question described Carrie buying a home, but months later, a hidden title issue surfaced, and she actually lost the property because of it. The question then asked, what compensates her lender for this loss? This really hones in on whose loss is covered by which policy. Getting this straight might have been one of those points needed to push past that 83%.
It's a critical distinction. First, let's just quickly recap the purpose of title insurance overall. It's designed to protect against financial losses that arise from defects in the property's title problems that existed before the policy was issued but weren't discovered during the title search before closing.
Like old liens or maybe a forged signature somewhere way back in the chain of title.
Exactly. Things like unreleased mortgages from prior owners, errors in public records, forged deeds, undisclosed heirs suddenly making a claim, things that could cloud the owner's rights or the lender's security.
Okay, so it protects against historical problems. Now, there are two main policies in a typical transaction, right?
Correct. There's the owner's title insurance policy. As the name implies, this protects the buyer or owner of the property. If a covered title defect pops up after they buy, this policy helps cover their financial losses, legal fees to defend their title, potentially up to the policy amount, which is usually the purchase price. This policy is generally optional for the buyer, but very, very highly recommended.
Protects the owner's equity and right to the property. Makes sense. What's the other one?
The other is the lender's title insurance policy, sometimes called a mortgagee's policy. This policy specifically protects the lender's financial interest in the property. Because the lender is putting up a significant amount of money secured by that property, they need assurance that their collateral, their security interest, isn't jeopardized by pre-existing title flaws. This policy is almost always mandatory as a condition of getting a mortgage loan.
Mandatory for the lender. Okay, so back to Carrie's situation. She lost the property, a huge loss for her, covered hopefully by her owner's policy if she got one. But the question specifically asks, what compensates the lender? That immediately tells us the answer must be the lender's title insurance policy.
Precisely. The lender's policy ensures that their investment, the outstanding loan balance, is protected if a title defect surfaces that diminishes the value of their collateral or even invalidates their lien position. It safeguards their money, even if the borrower, Carrie, loses the property itself.
It's a perfect example of risk management in finance, isn't it?
It really is. Lenders mitigate their substantial financial risk by requiring this policy.
Sure.
It guarantees that their loan is secured by a title that's clear up to the policy date, protecting their investment against hidden historical issues. It shows how intertwined the financial protections are. The buyer protects their equity with an owner's policy. The lender protects their loan with a lender's policy. Understanding who pays for which and who benefits from which is key knowledge for guiding clients.
Okay, from title protection, let's shift to something seemingly simpler, but where precision is just as vital. Calculating volume and units. This question involved a garage with dimensions, 15 feet long, 20 feet wide, 25 feet tall. It asked for the volume. The math isn't hard, but the units. That's often the stumbling block.
Yes, it's basic geometry, but it's amazing how often the units get mixed up, especially under exam pressure. The first key is to clearly distinguish area from volume. Area is two-dimensional, length times width. And it's always measured in square units, square feet, SQNFT or FTA, square meters, etc. It measures a flat surface.
Like the floor space of the garage.
Exactly. Volume, however, is three-dimensional. It measures the total space inside an object. You calculate it by multiplying length times width times height, and volume is always measured in cubic units, cubic feet, ATR, AEO, cubic meters, etc.
So for the garage, the calculation is straightforward. 15 feet times 20 feet times 25 feet. Let's see. 15 by 20 is 300 times 25 is 7,500.
Correct. 7,500 is the number. But the crucial part, the part that was likely the focus of the correct answer choice, is the unit. It's not just 7,500. It's 7,500 cubic feet.
Not square feet.
Definitely not a square feet. That would only be the area of the floor. 15 by 20 is 300 square feet. Saying the volume is 7,500 square feet is fundamentally incorrect. You need the cubic unit to represent the three-dimensional space, the capacity for storage. Getting the number right but the unit wrong is a common mistake.
And the real-world implication here for you as an agent, why does this matter beyond the test?
Accuracy in measurements in units is absolutely fundamental in real estate. If you misstate units in a listing, say you list the volume of a storage space in square feet instead of cubic feet, or vice versa, it can lead to significant misunderstandings. It affects how buyers perceive the usable space, it impacts value calculations, it can cause issues with contractors planning renovations.
I can see that. A buyer expecting 7,500 square feet of storage would be sorely disappointed with 7,500 cubic feet if they didn't understand the difference.
Exactly. Clear, accurate communication of dimensions using the correct units is vital for everyone: buyers, sellers, appraisers, architects, inspectors. A simple unit error isn't just a typo. It can lead to real financial miscalculations or flawed design decisions down the line. Precision matters immensely.
Okay, let's look at another way things can end, specifically agency relationships. This question dealt with agency termination by destruction. It asked something like, how is agency termination classified when the property itself ceases to exist? This tests your knowledge of the different ways agency can end, particularly the involuntary ways.
Right. Agency agreements don't always end because the job is done or the parties agree. Sometimes external events force termination. We generally group termination methods into two broad categories: acts of the parties and operation of law.
Acts of the parties would be things like mutual agreement to end it, or one party firing the other.
Exactly. Mutual consent, revocation by the principal, renunciation by the agent, breach of contract. Those are active choices or failures by the people involved. Operation of law, on the other hand, means the agency terminates automatically due to certain events or circumstances, regardless of what the parties want.
Okay, so what falls under operation of law?
Several things.
Yeah.
Completion of the purpose, the house sells; expiration of the agreed-upon term; death or incapacity of either the principal or the broker; bankruptcy of either party; loss of the broker's license; and, relevant to this question, the destruction or condemnation of the subject property.
Destruction or condemnation. So if the property, that's the whole point of the agency agreement, is gone, the agreement ends automatically.
Precisely. Destruction specifically refers to the subject property, say the house being listed, ceasing to exist in its essential form. Maybe it burns down in a fire, gets completely destroyed by a tornado or earthquake, or suffers some other catastrophic event that renders it fundamentally gone or unusable. If there's no property left to sell or manage, the agency agreement automatically terminates by operation of law. Its subject matter has been destroyed.
Now, you also mentioned condemnation under operation of law. How is that different from destruction? The question might have offered both as options.
That's a good clarifying point. Condemnation is also termination by operation of law, but it's a specific legal process. It's when the government exercises its power of eminent domain to take private property for public use, like building a highway. The owner is forced to sell to the government. While this also terminates the agency agreement because the client no longer owns the property to sell, it's a governmental taking, not physical obliteration. The question specifically mentioned, the property ceases to exist, which aligns more directly with physical destruction.
Okay, so both fall under operation of law, but destruction fits the scenario of the property being physically gone. The practical insight here seems pretty straightforward. You can't represent the sale of something that isn't there anymore.
It sounds obvious, but it legally clarifies when your duties end in such unfortunate circumstances. It dictates the end of the agent's responsibilities automatically.
And it must impact things like commission too, right? No sale, no commission.
Generally, yes. If the termination happens by destruction before a sale is procured, typically no commission is owed. It also radically shifts the client relationship. You might pivot from being their listing agent to maybe helping them navigate insurance claims, but the original listing agreement itself is legally finished. The entire dynamic changes instantly and automatically by law.
All right, let's tackle our final tricky area from your practice test questions. Unilateral versus bilateral escrow instructions. The scenario described Amani selling to Joe. After signing the contract, it said each delivered their own set of escrow instructions to the escrow agent. The question was likely, how can these instructions be described? This gets into the procedural details of closing, which can vary.
Yes, this is about the mechanics of how the escrow agent receives their marching orders. First, let's be clear what escrow instructions are. They are detailed, specific directions given to the neutral third-party escrow holder. They spell out exactly what needs to happen before the deal can close, things like handling the money, processing loan documents, prorating taxes, recording the deed. Both the buyer and seller must agree to these instructions for escrow to proceed.
So they're the final detailed rule book for the escrow agent, agreed upon by buyer and seller. Now, what's the difference between unilateral and bilateral?
It's about how those instructions are delivered and documented. Unilateral instructions means that the buyer prepares and signs their set of instructions, and the seller prepares and signs their own, separate set of instructions. The escrow agent then follows both sets, ideally ensuring they are consistent. This method is actually quite common in Northern California.
Okay, so two separate documents, one from each side. What's bilateral?
Bilateral instructions involves both the buyer and the seller signing the same single document containing all the agreed-upon instructions. It's a joint set of directions. This approach is more prevalent in Southern California.
So the key phrase in the question, each delivered their own set. That's the dead giveaway for unilateral instructions. Amani sent hers, Joe sent his separately.
Exactly. That phrasing points directly to unilateral instructions. It's largely a matter of regional custom and practice within the state.
Does it make a practical difference which method is used?
Functionally, both achieve the same goal if done correctly. However, it's important to know that if there's ever a conflict between the two sets of unilateral instructions, or between the instructions in the original purchase agreement, things can get complicated. Generally, the most recent signed document holds sway. If the parties can't resolve a conflict, the escrow agent might have to file an interpleader action, basically asking a court to decide who's right and how to proceed to protect the agent from liability.
Okay, so while it might seem like a small procedural detail, understanding unilateral versus bilateral helps you understand the closing process, potential regional differences, and even how conflicts might be handled.
Precisely. It underscores the absolute need for clarity and consistency in those instructions, regardless of the format used. Any ambiguity or conflict in the escrow instructions can cause significant delays or even derail the closing entirely. Whether unilateral or bilateral, making sure everyone is on the same page with the escrow agent is critical for that smooth finish to the transaction.
Wow, okay. We have covered a lot of ground today, really digging into some complex areas. We've untangled the subtleties of agency, ostensible agency, estoppel, confidentiality, sub-agency, dual agency, those core duties. Then we clarified property types like PUDs versus condos and ownership forms like community versus separate property and freehold estates. And finally, we nailed down some critical transactional details like lender's title insurance, volume calculations, agency termination by destruction, and those escrow instructions. You should now have a much clearer understanding of those specific concepts that might have felt a bit fuzzy on your way to that strong 83% score.
Absolutely. And if we zoom out for a second, connecting all these pieces, what emerges is a clear picture of just how important precision, ethical conduct, and meticulous attention to detail are in day-to-day real estate practice. These weren't just abstract exam questions we discussed. They represent real-world scenarios, legal requirements, and ethical obligations that form the blueprint for being a successful, trustworthy, and compliant agent. Mastering these nuances isn't just about passing the test, it's about building a solid foundation for your entire career.
So what does all this mean for you right now? Take this deeper understanding, this newfound clarity, and revisit those sections in your study materials. Look at practice questions on these topics again. And remember, every time you have one of those aha moments where the why behind the rule clicks into place, you're getting closer to true mastery. Don't just aim to memorize facts. Strive to understand the reasoning, the context, the real-world application. That's what builds lasting knowledge.
Yeah, that understanding of the why is really what separates competence from expertise.
Couldn't agree more. Keep putting in the effort, focus on understanding, not just memorizing, and you'll absolutely nail that exam. More importantly, you'll be well prepared to serve your future clients effectively and ethically. You've definitely got this. Keep up the great work.